Hi, my name is Robert Hetzler from qdrovideo2.com, and I've been doing a video series on trying to educate either my clients or divorce attorneys in general on retirement benefits, retirement accounts, and all things financial when it comes to divorce. And one of the topics that I think, and I've been teaching through webinars, and I'm building webinars now, but this is a free video series. This is really just to help attorneys understand some of the differences in retirement accounts. So I want to talk today just briefly about a couple of things. One being the difference between defined benefit plans and defined contribution plans. Now, defined contribution plans by definition are where an employee contributes through their paycheck or through their payroll a certain amount of money that comes out each and every pay period. Employers typically will match that up to a certain dollar amount, either 3 or 6%, but usually there's a cap on that. Some examples of 401k or 401ks, 457s, 403bs, which are normally for public employees. 457s are for state and municipal employees. Thrift savings plans, those are for federal employees. But they all have the same name, which is defined contribution plan. So they all act and operate the same way. So what divorce attorneys need to know in terms of defined contribution plans is that they have a lump sum value, meaning they have a value as of the certain date. And your job as the attorney is to find out which part is marital. And if it's all marital, that makes the calculations easier. If there's a non-marital piece to it, then certainly you might have to hire a professional, or the parties can agree, depending on if the records are available. That's usually the biggest issue, is if you have records not available in a case where someone had a 401k 5 or 6 years and then got married and stayed married 20 years, and then they want the calculation done on the earnings for the 4 or 5 years they were married before they got married, and then brought up to today's present value. Obviously, you may need a professional should that be the issue. But the bottom line is, when it's a defined contribution plan, you can certainly you certainly want to include it in the agreement, the percentage that they're going to receive or certain dollar amount. But the biggest thing you want to think about is you want to make sure that earnings and losses is addressed either by excluding them or including them in the agreement. And what I mean by that is, a lot of times you sign an agreement on April 1st, let's say, says the husband shall receive 50% of the wife's 401k as of April 1st, 2015. Well, what happens when by the time the final judgment is signed, by the time the quadro's gone through the pre-approval process, then signed by the judge, then ready to be implemented by the plan administrator, we're looking at September here. 4 or 5 months have gone by, and nothing in the settlement agreement says anything about earnings or losses. So 4 or 5 months, it could be a big deal of market fluctuations, especially in an up market, a bear market, certainly going to have the adverse effect. So as you can imagine, that one party or the other is going to take a different position on what they intended the agreement to mean the longer out in time that we're talking about. I had a case one time where someone was to receive $11,000 in 1989 and didn't say anything. The agreement was completely silent on earnings and losses. And in 1989, I was hired in 2010 to do the 401k division. I asked that's a big question, because every quadro requires an exclusion or an inclusion of market fluctuations or earnings and losses. So in other words, the date that they decided to divide it, they knew that it was worth, say in this instance, this example, 11,000. But it could be 4 or 6 months, it could be, in my example, 10 or 12 years before they actually get around to dividing it. I never recommend that, but it certainly happens all the time. If earnings and losses aren't addressed in there, then you have the potential for litigation again to figure out what was the intent of the parties, because that was completely left out. So in this particular case, the woman had 11,000 coming to her, back in the 90s, and now in the 2000, 15 years later or so, that same 10,000 was worth maybe 75 or 80,000. And so obviously her position was that, yes, of course, gains or loss were supposed to, market fluctuations were supposed to impact my portion. And then the other side of the coin was his position is, no, they weren't. It was always supposed to be 11,000. It's her fault if she didn't do the quadro. So you can imagine, depending on how the market goes, now if the market had gone down and the amount was going to be lower, I'm assuming the the parties may have changed their story a little bit, but the bottom line is it can all be avoided simply by putting in there whether gains or losses or market fluctuations impact and what impact they do have. And generally, they are included. Now, we'll tell you in instances where you have a client that maybe it's a non-financial spouse, someone that's really concerned about money and really has done a tight budget and they need $12,000 and they don't want less, they don't even want more, they need $12,000. There are cases that come out like that. And in those cases, they don't want to bear any risk. Most cases, the market goes up, but we've all experienced the 9/11. We know that there's definitely bubbles bursting all over the place, especially in the last 10 years. So certainly the adverse can happen and the market goes down. Well, if the $12,000 in my example is for sure what that client wants and the other side is okay with it, then simply just put in there that earnings and losses shall be excluded from the equation. And that way the $12,000 is going to come to her, in my example, no matter what it would be. If it had that $12,000 actually gone up and now it's really 15 or 16, she's still only going to get 12. And the participant is going to get the benefit of all the gains and losses that's going to stay in his account. Now the reverse is true. That 12 actually turned out to be 9 or 10. She's still going to get 12 and then the participant's going to eat it. So bottom line is, as long as both parties agree on that, that's fine. But generally speaking, earnings and losses probably are going to be included, but you would be amazed at how many agreements, I'd say half the agreements dealing with defined contribution plans is just completely blank and it's not dealt with. So I think the takeaway is that if you've got defined contribution plans, which we talked about, are 457s, thrift saving plans, 403bs, and 401ks. 401ks are private employer plans. Those are the ones we hear the most about, but the other ones I named operate the same. They are defined contribution plans. Anytime you have those, you want to include a statement that says whether earnings and losses or market fluctuations are or are not included or excluded from the calculation. Very important. Don't make the mistake of not dealing with it. The only other caveat that I want to say is when dealing with those types of plans, the defined contribution plans, a lot of times parties want to equalize the accounts. Equalizing the accounts means, wife has 4 accounts, husband has 4 accounts, whether IRAs, 401ks, whatever. And they don't want to do a quadro and pay to have a quadro done for each of these accounts. That would be 8 or 9 quadros. They want to add them all up and just see what the total would be, divide it by the calculation or the agreed to amount in the divorce, and then figure out and take it all from maybe 1 or 2 of those accounts. Say in my example, the wife had a little bit more once you added it up, and so she needed to take out $10,000 from one account to bring it over, or $5,000 from 2 accounts, whichever way it made sense. But try to minimize the amount of quadros that needed to be done. That's certainly fine. I encourage that. The one thing that you got to be careful of is not to put something like this in the agreement, something that says that the parties agree to equalize X, Y, and Z account. It turns out to be 8 accounts, so the parties are agreeing to equalize all 8 of these accounts, and the parties agree that market fluctuations or gains or losses shall be included in these calculations for all the accounts when equalizing. Well, that's an impossibility. It can't be done. And here's why. When you equalize the accounts, you're basically drawing a line in the sand on that day and saying these accounts are worth this amount of money, and because of that, now the wife, and following with my same example, the wife owes the husband $10,000, and it's going to be taken out of ABC Corporation 401k account. So you can and you should deal with the market fluctuations on the one account that's being used to offset. So in other words, the ones that you've already equalized that are not being offset, you cannot attribute earnings and losses to those, because that's already had a line drawn in the sand. Those have already been computed as of a certain date for equalization purposes to determine the 10,000 in my example. And then that 10,000, yes, that 10,000 can be and should be affected by market fluctuations, or is not included or excluded, either way. But certainly you can't do them all. So you can draft up something that says the party shall equalize these accounts, list out the specific accounts, and if you've already done the calculation and know, You say, and the 10,000 that is being equalized that came out due, the wife shall pay the 10,000 from XYZ ABC Corporation 401k, and that account shall be subject to earnings and losses from the date of signing this agreement or this date forward through the date of distribution. So that way, when we prepare the quadro, we certainly can do that for you. But when we get agreements that say the parties shall equalize these accounts and all the accounts should be subject to earnings and losses, that's actually an impossibility. So certainly want to avoid that. Now, I know I talked a little bit longer than I wanted to about defined contribution plans. So now, defined benefit plans are entirely different. Defined benefit plans are about getting some type of benefit in the future. In other words, there's no cash value right now in today's dollars necessarily. It's about years of service to the company, payroll or amount of pay in terms of calculating your benefits, and a bunch of other actuarial type of calculations. But again, defined benefit plans are not something that normally has a cash balance, so certainly cannot equalize a defined benefit plan and a defined contribution plan. Now, there's a very rare circumstance where you could come close to that, and that's if you want to incur taking a defined benefit plan and actually getting it at present value, doing a pension valuation as of a certain date, so that way you bring a defined benefit plan based on in today's dollars, and then you have a value to assign to it. And a lot of times, the only times that's done is if the parties are generally in agreement that they don't want to touch the pension holder's pension, but they do want to assign some value to it so that the other party gets some credit either through their own defined contribution plans or their own defined benefit plans. So if that's the case, then you can value or have value to defined benefit plan to come up with today's dollars. But the real issue is not earnings and losses. Matter of fact, I've seen agreements where they talk about pension accounts, which are defined benefit plans, and then discuss how earnings and losses are going to be included or excluded. And that only is defined contribution plans. Never say anything about earnings and losses when it comes to defined benefit plans, because it doesn't matter. It's non-existent. But what is existent, and one thing I just want to spend a minute on, is survivor benefits. Survivor benefits, I cannot tell you how important it is. This is probably the most litigious area. If you hear about attorneys getting sued or somebody getting sued for quadros in any capacity, it's about almost inevitably something to do with survivor benefits. And here's why it's important. One is, a lot of people, once they say, well, I'm getting 50% of my wife's or my husband's retirement, but they don't retire for 10 more years, I'll worry about the quadro in 8 years, and I'll still have 2 years ahead of time, so I don't have to worry about it. Well, first off, there's a couple of things you need to know about that. One is, certainly after your divorce, you want to do it right away. If for no other reason, just worry that your spouse may get remarried, because if a spouse gets remarried or the spouse gets hurt and is enforced into an early retirement, or the spouse dies, any of those life-changing events will certainly impact on some level the benefits received to the alternate payee, the spouse receiving the benefits, if there's not a quadro in place. It's certainly not going to make it an easy process. So any of those life-changing events like life or like death, remarriage, or early retirement because of an injury or disability is certainly going to change the dynamics of that. If a quadro is not in place, because if a quadro is in place already, even if the retirement doesn't take place for a long time, that's why you get it done right away, then you have already set up the protections necessary so that if those things do have, then you don't have to worry about it nearly as much. So certainly we want to make sure that quadro is done right away. The only other thing that I'll say on defined benefit plans is not only are the things we talked about life-changing in terms of benefits, but there are a lot of plans that say, the elections need to be changed to reflect this quadro by so-and-so within 2 years or within 1 year of the divorce or something. So you have to be careful. Not only do you have the life-changing types of things, but then you have the plan over here that are governed by ERISA, these plans that have something in there that they put in their own time frames. If you don't know about those time frames, you haven't been told about those time frames, you can't just let years go by, because I've seen many plans that have, 1 year after the divorce, the quadro must be done, or 2 years after the divorce, the quadro must be done. If not, you waive your right to this survivor benefit or something. And the reason that's important is the person receiving the money from the employee spouse, so they're getting a benefit as a result of the employee working. Now I understand they're getting that benefit because they were married and that's part of the divorce process, but you want that spouse, if possible, if the plan allows for it, most of them do as long as you do it early enough, meet the deadlines, can continue to receive that benefit even if the employee spouse predeceases her or him. So in other words, you just don't want, by missing a deadline or not doing something in a timely fashion or not addressing something in the settlement agreement, that the spouse that's supposed to receive the money from the employee spouse, so the alternate payee we're talking about, now only gets a benefit until the spouse retires or until the spouse dies. So what if you have the case where you have a spouse who's in poor health or maybe even older working spouse, so 15, 20-year difference in their ages. This spouse dies, then the alternate payee spouse goes on living 20, 25 years after, but they did something wrong in their timing and the not having the proper protections or language in the settlement agreement, and that particular spouse only received the benefits till this spouse died. So she or he may have given up 20 or 30 years of actual retirement benefits that can't be undone. And that could be because somebody remarried, somebody made an election at retirement, an early retirement before a quadro was ever put in place, because those elections are going to govern no matter what the family court judge says. It's going to go by the elections in almost every plan, what's been set, and that law is pretty firm across the country. So just because of that, your client could have potentially lose out on 20 or 30 years of benefits, monthly amounts. Now you can obviously see why this is the most litigious area, why a lot of divorce attorneys refer out, and why I keep a lot of malpractice insurance. Because even though, knock on wood, I have never had a claim, even I worry about it. And I'm not the one writing the settlement agreements. I'm only facilitating what's already been agreed to in the settlement agreement. My challenge comes into place when nothing has been discussed in the settlement agreement. Then I got to go back to the attorneys and try to figure out if there can be an agreement reached and if we can do it without going back to the court and all that kind of stuff. So all of this can be eliminated, obviously, if you got a pension or a quadro professional earlier on in the process, or that would be possible. Now, I know that finances are limited in some cases, so you got to weigh the cost versus the benefit, but just a lot of this stuff can be done by the divorce attorneys, just knowing, basically having a good understanding of the types of plans and what can be done and what has to be included. So I've actually made a checklist, and it's available on my website, but if you email me, I'll certainly send it to you. It's a one-page checklist, talks about defined benefit plans, defined contribution plans, and lets you know what to be looking for depending on what type of plan is in place. And it's a real handy thing you can fold up, carry with you. In today's world, you can probably scan it right onto your iPhone or your mobile device of some sort, but it is something that you could carry. I know that many mediators have this at their mediation table to talk about, and so I'll certainly make that available to you. I hope you've liked these video series. This is the second video. As you can see, if you missed video one is going to be right here on the same page. You can click and watch that video. There'll be another third and final video coming up in about 6 days or so, and I hope I'll look for you there and seeing you there. And then we have our, the webinar that launches in October. It's a webinar you watch at your convenience and all that good stuff, and provide feedback that rolls into a second webinar and all that good stuff. So certainly I'll tell you more information about that. But right now, just enjoy this content. I hope it's bringing some value to you. And if you have any comments or anything, certainly call me directly. My name is Robert. Email me, robert@qdrovideo2.com, and I'll look forward to seeing you on the next video. Thanks.